I'm sure most of us are aware of the fact that RTI is a constitutional provision. Article 19 gives protection of certain rights regarding freedom of speech, etc. All citizens have the right to freedom of speech and expression, in which they have said right to publish also comes under this. Right to information also comes in this. And the last 70 years, right to speech and right to publish have expanded, largely because of the courts. What restrictions can be put on this? Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law, insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. My submission is that anything relating to privacy or section 81J would be covered only by decency or morality. But does anyone have a counter opinion saying, no, this will also... Anybody has a different opinion? Do you agree that only decency or morality should be the topic out of this? Therefore, Article 19(2) of the Constitution does not permit even reasonable restrictions on other matters. Now, the I'm highlighting 4 or 5 cases. Aditya Bandyopadhyay case, August 2011. This is a paragraph in the judgment. There was no reason for putting this paragraph. Koi logic nahi tha, kuch reason nahi tha. But this is what has been written. Indiscriminate and impractical demands or directions under RTI Act for disclosure of all and sundry information unrelated to transparency and accountability. अभी वो what is related to transparency and accountability इसका तो कोई definition कोई हो नहीं सकता है. And the functioning and eradication of corruption would be counterproductive, as it will adversely affect the efficiency of the administration and result in the executive getting bogged down with the non-productive work of collecting and furnishing information. The Act should not be allowed to be misused or abused to become a tool to obstruct the national development and integration, or to destroy the peace, tranquility and harmony amongst its citizens. Nor should it be converted into a tool of oppression or intimidation of honest officials striving to do their duty. The nation does not want a scenario where 75% of the staff of the public authorities spend 75% of their time in collecting and furnishing information to applicants instead of discharging their regular duties.
Stretched it to such an extent.
No, according to me, this statement, peace, tranquility, harmony, integration, should apply to terrorists. Not to sit. In fact, when this judgment had come, I was also upset. I was in the commission at that time. And I said we should do something. But then some people said, यार किसी को पता नहीं चलेगा सुप्रीम कोर्ट का ये जजमेंट, इसको बढ़ाओ मत, नहीं तो फिर ये सबको मालूम पड़ेगा. I was a fool to believe नहीं मालूम पड़ेगा. I think we should have started opposing at that stage. But now that's history. The feeling I had and what others also said is, यार कोई साला सुप्रीम कोर्ट जजमेंट कौन पढ़ता है यार इसको. If you raise the issue, it will become more popular and everybody will focus on this. Anyway.
But in a lighter way, that's the only work they do.
Okay, consequence. License to call RTI applicants oppressors, misusers, obstructing and hindering the nation's progress, integration, peace and harmony. Ye court has been made in lot of judgments of commissioners, even of appellate authorities and PIOs. It follows that they could be condemned and attacked verbally. What we must realize is physical attacks arise from the fact कि एक बार आपको बोल दिया एक गुंडा है, तो आप गुंडे को शायद नहीं मारेंगे, पर कोई मारेगा तो आप खुश होते हैं, यार अच्छा हुआ. अगर मार सकता हूं तो मार, I can also kill such a person. This whole concept of RTI users being misusers, as far as I know, there are human rights defenders. According to one count, in the last 15 years or so, 15 or 20 years, about 47 human rights defenders have, journalists, sorry, my apologies, journalists who have fought for human rights have been killed, murdered by the state. Not by the state, by some people or the other. Compared to that, 70 RTI activists have been killed in about 12 years' time, 12, 13 years' time. And this will increase. Because so long as you have a situation where you say RTI is a nonsense, is misuse, I think we are looking at serious problems. Girish Ramchandra Deshpande versus CIC. The apex court held that copies of all memos, show cause notices and orders of censure, punishment, assets, income tax returns, details of gifts received, etc. by a public servant are personal information as defined in clause 81J and hence exempted and cannot be furnished in the RTI Act. 81J does not exempt personal information. Here, of course, there is a small problem जिसको मैं बोलता हूँ भाषा का problem in India. इसका जब convert किया, when you translate this into Hindi or Marathi or other languages, there is no word for privacy. Therefore, the word that is used is nijita. Nijita is personal. What needs to be referred to is the English version, but a lot of popular people, PIOs, etc., वो हिंदी version पढ़ते हैं, मराठी पढ़ते हैं, गुजराती पढ़ते हैं, and I don't know in Tamil, etc., what happens. The word they get is nijita. So they are convinced that nijita means personal. Nijita is clearly a translation of the word personal. It does not connote what privacy means. Section 81J exempts information which I have quoted here, provided that the information which cannot be denied by Parliament or a state legislature shall not be denied to any person. Has been read by the court, in my view, as information which relates to personal information, unless the public information officer or the appellate authority or case may be satisfied that the larger public interest justifies the disclosure of such information, and this sentence has been cut off. In fact, in Girish Deshpande, when quoting 81J, they don't even quote this proviso. It's just been omitted. This, therefore, is a very poor judgment, but today it's become the benchmark for RTI. This is like a major amendment to the law which only Parliament is authorized to do. It is a constriction of RTI beyond what is permitted by law or constitution. Neither the constitution permits it. All personal information cannot be exempt. Giving your age, your action taken against you, your assets, cannot be considered violative of decency and morality. Therefore, I would submit this is a violation of Constitution as well as of the RTI Act. Now, I'm just quoting an earlier R. Rajgopal and another judgment of the Supreme Court itself. Girish Deshpande violates this without even acknowledging the earlier judgment. The ratio decidendi, as it is called. We may now summarize the broad principles flowing from the above discussion. The right to privacy is implicit in the right to life and liberty guaranteed to the citizens of this country by Article 21. It is a right to be left alone. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing and education, amongst other matters. Some definition was given of what is privacy. Now we have no definition. Everything personal can be claimed as privacy. None can publish anything concerning the above matters without his consent, whether truthfully or otherwise, and whether laudatory or critical. If he does so, he would be violating the right to privacy of the person concerned and would be liable for an action which damages position may be different if a person voluntarily trusts. The whole point was ADR judgment said, except for things relating to privacy, and what is privacy was defined, all other information can be given. This was much before the RTI Act came. The ADR PUCL case, perhaps most of you are aware of, because of the ADR case, the Supreme Court in the ADR case said, citizens have a right to know the assets of those who want to become public servants. जिसको public servant बनना है, उसके assets के बारे में और उसकी बीवी के assets के बारे में, उसके dependent बच्चों के assets के बारे में लोगों को जानने का अधिकार है. In Girish Deshpande, the Supreme Court said, जो public servant है उसका asset जानने का जरूरत नहीं है आपको, कोई अधिकार नहीं है. उसने गलत काम किया, उसको सेंसर किया, इसका जानने का आपको अधिकार नहीं है. the Supreme Court has used the word, it is a matter between the employer and the employee. अभी सुप्रीम कोर्ट को जाके समझाना पड़ेगा कि एम्प्लॉयर कौन है. जब लोगों को पूछता हूं तो बोलते हैं गवर्नमेंट इज एम्प्लॉयर. हु इज गवर्नमेंट? इट इज द सिटीजन्स ऑफ इंडिया. वो सिर्फ एक एजेंट है. एम्प्लॉयर इज नॉट गवर्नमेंट एज इफ इट्स ब्रिटिश गवर्नमेंट. Employer is the people of India. We, the people of India, gave ourselves the constitution. And the ADR-PUCL judgment, in my opinion, was violated. The Rajgopal judgment was violated by the Girish Deshpande judgment. They have not considered these judgments. Therefore, classically, it would be called a per incurium judgment. And it's an SLP. Therefore, also some lawyers argue that it cannot form the basis of law. R.K. Jain, again now RTI again coming to 16th April 2013. This, you see the progression. The court held that relying upon the ruling made in Ramchandra Deshpande, the information is exempted from closure under 81J. Chapa maar diya. Ramchandra Deshpande is the precedent. Read with section 11 of the RTI Act. Now they came up with one more story. Para 13, under section 11(1), if the information relates to or has been supplied by a third party and has been treated as confidential by the third party, and if the PIO or record on the request made under the Act in such, the third party agrees to such request if the public interest in disclosure outweighs importance to any possible harm. Where a public information, this is what the law says. And what here it has been transferred to is, when it's a third party, information need not be given. Section 11 has been made an exemption, which is not as per law. Law in section 7(1) says the only information which can be denied is under section 8(1), 8 and 9. 9 relates to copyright. Section 11 cannot be. But R.K. Jain established the precedent of saying section 11 can also be an exemption. Canara Bank versus C.S. Sham and others. Information regarding transfer and posting of the entire clerical staff from so-and-so to so-and-so in all branches of Canara Bank. This information was in relation to the details of individual employees, such as the date of joining, designation, promotion, date of his/her joining the branch, where he/she is posted, and the authorities who issued the transfer orders. Para 12 in the judgment. In our considered opinion, the issue involved herein remains no more res integra and stands settled by two decisions of this court, Girish Ramchandra Deshpande and R.K. Jain. अभी गिरीश देशपांडे का जजमेंट था, उसको 2 छापा लग गया कि ये तो परफेक्ट है, अभी इसको चैलेंज ही नहीं कर सकते हो आप. Para 14, in our considered opinion, the aforementioned principle of law applies to the facts of this case in all force. It is for the reasons that firstly, the information sought by respondent number 1 of individual employees working in the bank was personal in nature. Secondly, it was exempted from being disclosed under section 81J of the Act. How they come to the conclusion of 81J is not mentioned even in Girish Deshpande. Incidentally, in Girish Deshpande, it's like a comedy of errors. Girish Deshpande judgment says we agree with the commission. Some people say commission has your reasons. Yeah, that is what the court agrees with. Fair enough. Commission gives no reason in that Girish Deshpande judgment, but says we are relying on an earlier judgment of the commission on income tax matters. Fair enough. Go to the other judgment. The other judgment gives a ruling saying personal information shall not be given, relying on a Milap Choraria earlier judgment of the commission. The Milap Choraria judgment does not talk of a public servant at all. What started the story was a personal dispute, and that got converted into this. And now Girish Deshpande is a standard for all of these judgments. Effectively, all personal information may be barred. Wherever a person's name is mentioned, information may be denied, effectively making it very easy to deny information in most cases. And this UPSC, February 2018, I wasn't aware of this judgment. Somebody, in fact, sent me an email saying, sir, can I get an answer sheet? I said, yeah, of course you can. He said, the PI is refusing, quoting a Supreme Court judgment. I said, send me the Supreme Court judgment. I was shocked. When trying to, you can read this later, but effectively, again, Section 8 and other provisions of the Act, it says this information is not to be given. This is reproduction of para 34 in CBSE. In para 34 in CBSE, this was said, when trying to ensure that the right to information does not conflict with several other public interests, which includes efficient operations of the government, preservation of confidentiality, etc. It is difficult to visualize and enumerate all types of information which require to be exempted. मतलब पार्लियामेंट ने जो exemption दिया वो enough नहीं है. ये कानून हमको follow करने की जरूरत नहीं है. The enumeration of exemptions is more exhaustive than the enumeration of exemptions attempted in the earlier Act, that is Section 8 of the Freedom to Information Act. The courts and information commissions enforcing the provisions of the Act have to adopt a purposive construction involving a reasonable and balanced approach which harmonizes the two objects of the Act while interpreting Section 8 and the provisions. That means don't follow the letter of the law. Each one harmonizes. Commissioner will harmonize, then the PR will also harmonize, the appellate authority will also harmonize. If you want a decision, come to the Supreme Court. That is the impact of this. And they've overturned this, weighing the need for transparency and accountability on the one hand, and requirement of optimum use of fiscal resources and confidentiality of sensitive information on the other. We are of the view that information sought with regard to marks in civil services cannot be directed to be furnished mechanically. Situation of exams of other academic bodies may stand on different footing. So each examining body, you go to the court and you get a result. There are two examples I am enumerating here. DOPT, in fact, I just got the response yesterday. I had said I want the following information: total number of annual performance reports of these of IAS officers. I, on top put IAS officers, pending presently for over 1 year, 2 years, 3 years, and 4 years. Rejected based on 820 and गिरीश देशपांडे का एक पैराग्राफ कोट किया है उठा के कि ये नहीं देने का है, ये 820 है. इधर कोई आदमी का नाम भी नहीं आता है. Thane Municipal Corporation, there are reports that the Thane Municipal Commissioner has sent a letter complaint to the police about RTI users being blackmailers, extortionists, and asking for investigation action against them. I want a copy of the letter. Rejected, claiming exemption under Section 81J.